Now in session.
Thank you, Ms. Lindsay. And on behalf of Judge Stafford and Judge Golden, we are pleased to welcome Mr. LaGuire and Mr. Wolf for this oral argument, which is being live streamed for the public's consumption and to fulfill our obligation to have open courts. We will conduct the hearing in the same fashion as if we were all in the courtroom together. Each of you have 15 minutes to argue, and the appellant has reserved some of that time for rebuttal. Unless there are announcements, I will ask Ms. Lindsay to call the case.
Allan F. White Jr. et al. Versus Bradley County Government et al.
Thank you. And Mr. Wolf, you have the floor.
Thank you, Your Honor. Glad to be here and appreciate the court's attention to this case. The case basically revolves around what is meant by collateral estoppel. I think the burden of proof on that is especially pled defense, and the burden of proof, I believe, would be on the defendant. What happened was we had a case in federal court, and in June of 2018, the federal civil rights aspects of that case were dismissed by Judge Collier. And then the remainder of the state law claims were remanded to the Bradley County Court, where the case was originally filed in July of 2016. And this, of course, arises out of a wrongful death case that was filed by Randy Rogers, I think on July the 25th of 2016, a little bit before 1 year after the death of A.J. White at the hands of Tiffany Goodwin, a Bradley County officer. And our argument is that a federal case for civil rights is different from the remaining state claims. As we've cited the case, I think, in our brief there to the effect that the federal case basically has to, you have a situation where you have Fourth Amendment rights involved, and it's different from where you have just state law claims like they mentioned in the case, assault, battery, and things like that. And so, but at first, I think when we got to Bradley County in July of 2019, on the first motion that Mr. LaGuire made to dismiss, Judge Puckett decided against that motion. He said there were issues of credibility. And so that's part of the history of the state case. And he said that, this was a one person witnessed it, and that person is still alive, and she happens to be the defendant, but the plaintiff has the burden of proof. And of course, if the situation were converse, where the plaintiff had survived, their word alone wouldn't be enough to, of course, establish the case. There had to be other circumstantial evidence, but we only have, of course, one witness, and the other witness is unavailable, in our opinion, due to the fault of the defendant, Tiffany Goodwin. We established, I think we put credibility into issue in the state case. We had an affidavit from Devon Cooper about the prior relationship that he swore to regarding the officer and the decedent. We had also an affidavit put into the record from Carrie Green, who had talked to the decedent a few weeks before he died, and he told her that, according to the affidavit, that he was dating a female police officer. She warned him against doing that. And of course, whether or not there is an actual relationship bears on the whole character of the encounter. If it was just impersonal as opposed to people who'd known each other and also had been acquainted in what Devon Cooper said was a pretty familiar way.
Let me ask you a question, Mr. Wolf.
Yes, sir.
I'm trying to get my arms around the procedure that was utilized here in this case. And as I understand it, trial court granted summary judgment in different hearings. But what I'd like to know initially is, did the trial court grant summary judgment based upon the undisputed facts that were presented to it as a result on the remaining claims? Was that the basis of the trial court's grant of summary judgment, the undisputed facts, or did the trial court give some type credence to the remanded issues from the federal court?
They didn't give any credence to our issues, Your Honor. The federal court dismissed our case and remanded the state claims to the state court. And
Well, yeah,
go ahead.
I didn't ask that very well. When the federal court dismissed a portion of the lawsuit, it made certain findings of fact and conclusions of law. And then the case comes back to the state trial court, and motions for summary judgment were filed there. Were those issues that the federal court found, how were they treated by the state court, I guess is my question.
Well, at the very beginning, in the August of 2019 opinion, where Mr. LaGuire's motion for summary judgment or to dismiss was overruled, the judge found that there were credibility issues in the state court that may not have been present in the federal court. And of course, he changed his mind later that December 19th of 2019 and ruled against us. But the thing is, if he's in the federal judge, what was necessary to his decision, and Mr. LaGuire has pointed out cases under collateral estoppel, but one of those cases he's pointed out is that for it to have the collateral estoppel or res judicata effect, it has to be necessary to the decision. And it wasn't necessary for the federal judge when he considered a federal civil rights claim under the Fourth Amendment, which involves intentional conduct, it wasn't necessary for him to decide issues of negligence or state law claims or anything like that. Like the difference between murder, manslaughter, there's different degrees. And so, the case of negligence was plainly pled. I put it into the brief, and the judge never said that there wasn't any negligence or ruled on that. He just said the res judicata effect or the collateral estoppel effect of the judge's findings erased our entire case, whether we pled it under negligence theory or any other theory. And so that's why we had this appeal. I think that a federal civil rights claim does not, I mean, we have this in the brief. It does not address negligence. And it also, besides that, it's an ongoing case. The case was put back into Bradley County. And so we had a right, the case was ongoing. And so credibility also is an ongoing issue. And we came up with witnesses after the remand that materially affected the way that case was presented in federal and state court. It was a little bit different, but still it was ongoing. It was
Why is credibility an issue? You keep saying that, and I understand what you're saying, but I'm having trouble wrapping my arms around it.
Well, according to Judge, the trial judge, Judge Puckett, it was in 2019 in August. He found, he cited several cases, where he thought credibility was important. And in a case, especially where there's only two people, one dies, which leaves just one witness to testify. And it's important because of the way, we have to assume her facts. She said that she didn't know him, never saw him. She said that he was a complete stranger, except for, I think maybe they saw each other in high school one time years back. And our witnesses who have given affidavits have said, no, there was a relationship. There were prior encounters between them that were eyewitnessed. And I think that's important.
And that's relevant because why?
Well, because she's the only witness. If her credibility is impeached, then I think, I think there's a case that was decided, I think, last summer, TWB Architects. Yeah, it just came off the top of my head there. I think it was decided July. Well, actually, it was the summer of 2019, July the 26th. And it talked about how, when credibility, how somebody's version of how something happens, when that is the crux of their case, then once they're impeached, then it becomes really the sort of case that doesn't really merit summary judgment. And I think that's what the TWB Architects held, and we filed that case in, about the same time that we put it into the record, about the same time that the judge was deciding the case in August in our favor. But then, of course, he came back and then relied on the doctrines of collateral estoppel, and later on, he dismissed our case based on that, but he never did retract his findings of credibility. I asked him when I did my Rule 52 motion, which I've set forth in one of my arguments. I posed a question to the judge as to whether, in his opinion, or did he find as a fact that is the issue of someone's credibility ongoing, or was it frozen in the federal court? If it's ongoing, which I think it would be, then I think what our proof is subject to. I think it bears a lot of weight, and it ought to carry the day at least to get us to trial. And so but the judge declined that motion. But I think that should have been granted, because I do think that credibility of any witness can be challenged at any time. And I think in this case, where it's a one-person witnessed event, is very important.
So is there a dispute about the facts themselves that occurred?
Yes, sir. There is a dispute, and she's given some conflicting testimony herself as to what her position was when she was thrown to the ground. We don't, and plus I think at one time there were 3 bullets, and then there were 2 bullets, only 1 shell casing was found. I don't think we've ever been able to find the other shell casing. There is a witness there who's in the record who gave a statement to the TBI, Margie Workman, who was there and saw the defendant's father scouring the backyards of the homes of that subdivision where Mr. White died. He had a gun with him and was telling neighbors to go back inside the house and not to look outside. And so we think that bears strongly on the case too. I think that given the fact that it is just a one person, again, one person survives, the other person is unavailable to testify because of her conduct, in our opinion, wrongful conduct. And so we think that once that she's impeached and there's a conflict, I think that we deserve to go forward and have a trial. But, the civil rights, the judge did not dismiss, the state law claims. And this was an ongoing case. It was not dismissed and refiled or anything. It came right back to Bradley County, and we proceeded with the remaining state claims at that point.
Anything further, Mr. Wolf?
No, sir. I think that's
very good. Thank you. We'll hear from you on rebuttal, Mr. LaGuire.
Thank you. Good afternoon, Your Honors. I'm Thomas LaQuire of the Hamilton County Bar. I'm here for Bradley County and Deputy Tiffany Goodwin. As court well knows, it seems these days there's hardly a day goes by that we don't read or hear reports about law officers attempting to make a stop or arrest a suspect, and the use of force comes into play, and whether the amount of force used was necessary or excessive becomes an issue. In this case, I strongly believe, and I believe Judge Collier, the U.S. District Court judge, made it apparent in his ruling that in July of 2015, if Deputy Goodwin had not used the level of force she did against Allan White, she very likely wouldn't be alive today. And if you all have just will bear with me, just a few quotes from his findings of fact. He dismissed the civil rights claims. He found that she identified herself, ordered Mr. White to yield. He ran from her. She caught up with him laying down. She attempted to handcuff him. He then rose and resisted the arrest. She used her taser twice, trying to get him to submit before he threw her down, a much larger man than she is, and climbed onto her, began to choke her, began to beat her. She testified that she constantly asked him to stop and he refused, and she was in fear of her life. Ultimately, she had to withdraw her service weapon and point it back over the back of her head where he was on top of her in reverse and shot him. Otherwise, he likely would have killed her. And
Mr. LaGuire,
yes,
are these facts in dispute? Mr. Wolf says that, or indicated that some of these facts are disputed. So what's your position on that?
those facts are not in dispute, Your Honor. Some of the things that Mr. Wolf raises are minor details and discrepancies in what, how many rounds may have been fired. Judge Collier addressed those in his findings of fact. And most importantly, he specifically found that her conduct and her actions were objectively reasonable under the circumstances. These are the same issues that were before Judge Puckett in the circuit court. He, after considering it further, realized that Judge Collier had addressed those very issues, that the parties had had complete opportunity to litigate and put evidence before the court about those issues, that Judge Collier's judgment was final. The parties are all the same. And all of the criteria for determining whether collateral estoppel applies are applicable here. He found those. And so Judge.
Okay, yeah, that leads me to the question that I had asked Mr. Wolf, and that is,
Yes.
the trial court granted summary judgment to you or your clients
Yes.
in two separate instances.
Yes.
What was the basis for that grant? In other words, were those facts undisputed? Were they based upon what the federal court found, or were they based upon evidence presented in the state court and supported by appropriate citation, I suppose? So how did that?
Yes, they're all the same facts, but Judge Puckett did find two things. First of all, he found that the county was immune from suit under the GTLA because this is effectively a civil rights claim and they retained immunity. Secondly, he found that collateral estoppel did apply, and that was under the Parton case, I believe, Parton v. Scott, because Judge Collier had made these specific findings in his opinion, and all the evidence was before him, and it was the same evidence that was before Judge Puckett. There was no new evidence put before Judge Puckett other than this affidavit that Mr. Wolf has referred to, which is, I don't see how it's material at all to the facts of what happened that night. And he also had the opportunity to put that before the district court and did not do so, tried to add evidence after the district court judgment was final.
What was evidence, though, other than saying the federal district court found these facts in its decision when it rendered its decision on the part of the case that it dealt with? Was there evidence, was the same evidence submitted to the trial court in this case?
Yes, testimony, affidavits, deposition testimony was submitted to the trial court.
So the same summary judgment procedure was followed with the same evidence being introduced here?
Yes, and the reason for the two different hearings, I believe Judge Puckett just probably hadn't had enough opportunity to review what was quite a voluminous record. He was looking at it, I believe, on the first motion when he saw that affidavit as an issue of credibility, that as the trial judge in a GTLA case, that he would have to weigh the evidence, that it was something he wanted to hear testimony about. But then when he reviewed the case law further, Parton versus Scott and the provisions of the GTLA 2920-205, the immunity provisions there, he determined that the county was immune and that he was bound by the opinion and findings of Judge Collier on the doctrine of collateral estoppel to dismiss the case against Ms. Goodwin as well.
So was it his determination that he was bound by the doctrine of collateral estoppel, or that the facts that were presented to him entitled your clients to summary judgment? I guess that's what the distinction I'm trying to get to.
Yes, sir. I understand. I guess maybe I'm being a little bit thick about it and not seeing.
No, it's the question. It's a difficult question. It's hard to articulate.
Yes. No, I think you're articulating it fine, but his opinion, he did specifically refer to, he wrote a rather lengthy opinion, and he went through the testimony, and he attached Judge Collier's opinion to his opinion. He recited at length from it, just as was done, I think, again in the Parton versus Scott case. And he said that those findings were binding on him under the doctrine of collateral estoppel, using the 5 elements that we look to see if collateral estoppel applies. And pointing out, as the other cases do, that just because you frame the claims as negligence or tort claims doesn't change the fact that they all are based on the same incident, the same actual facts of what happened, and whether you call it a civil rights claim or call it a negligence claim, collateral estoppel can apply. He did the same thing with the GTLA claim. He said you can call that a negligence claim if you want to, but because the exception to the removal of immunity to local governments is based on arising out of civil rights, it doesn't matter, the cases say. In fact, 2 opinions that Your Honor wrote say it doesn't matter whether it's you call it a negligence claim, call it a tort claim or not. If it arises out of events that involve civil rights, then the GTLA removal or exception to removal of immunity applies, and you can't bring that claim regardless of what you characterize it or how you frame it. And those are, of course, the Cochran case and the Marola case that the court just issued a little over 2 years ago in 2019. Very similar facts as the one we have here, particularly the Cochran versus the Jonesboro case. I think it's almost exactly the same procedurally. The case brought in federal court, dismissed by the federal court, but as is often the case, they don't want to get involved in determining state law issues. So he just declined to exercise supplemental jurisdiction in that case. It then went to state court, and the state court said this is based on civil rights, regardless of what you call it. And it was dismissed, and this court affirmed that decision. And I think that's pretty much it. The local government is immune under 29-205 because this case arises out of civil rights, which is clear from the complaint, and because of the collateral estoppel doctrine on the issues of excessive force of Officer Goodwin. Unless the court has questions for me, that's all I have.
Hearing no further questions, thank you, Mr. LaQuire. Mr. Wolf, your rebuttal. Please unmute Mr. Wolf.
Okay, I got it. Okay. The opinion that the judge gave in December of 2019, that was based on res judicata. I'm sorry, on collateral estoppel or res judicata. Because if you look at the title of his opinion, it's just an addendum to the August findings where he brought up the issues of credibility, and those were never retracted. He never said I was wrong about credibility. He just says the case is determined by the federal court ruling. Even though the federal court remanded the case, it was an ongoing case, and they didn't conclude state law claims. So that's what I believe the correct version is on this. And as far as Mrs. Goodwin's injury, it was x-rayed. All the x-rays were negative. She was able to go to the hospital. Her lawyer, Jimmy Logan, a Bradley County lawyer, showed up the night it happened. Mr. Watson called him to the scene, and Mr. Logan showed up there, stayed with her during the questioning about the TBI and everything else, and then took her to the hospital. A Bradley County lawyer right there at the scene of the incident. And so that's another thing I think that deserves some sort of consideration. The judge, again, like I said, never did retract, what his findings of credibility were. Now, as far as the civil rights case, well, the judge didn't rule on the state law claims, especially regarding negligence. Now, one thing that's happened in the news lately, Mr. Wire talked about the fact that this is sort of a current thing, police misconduct, or at least allegations of it. Well, we have a case up there in Minneapolis just last week where somebody drew their taser instead of their pistol and shot somebody. Well, Is that negligence, or is something like that negligence, or is it a civil rights claim? Is it something where they didn't use ordinary due care and kill somebody? Well, that could be a negligent action, and then there could be remedies there for not drawing the right weapon. So the same thing is here, the negligence part, which it was alleged 2 or 3 times by Mr. Rogers in his 2016 complaint. There's never been any finding to negate that. And Judge Collier, when he issued his findings on the civil rights claim, the only thing necessary with his decision was to find that there wasn't any violation of civil rights. To violate somebody's civil rights, you have to be a lot more than negligent. And I've cited quotes or cases to that effect in my brief. It has to be at least at a minimum unconscionable, intentional, or extremely reckless sorts of conduct. That's what's encompassed by a Fourth Amendment violation, not just mere negligence, or as I would say here, a misapprehension of the risk. In other words, she, like a manslaughter, she was a little bit overly overcome by the events and then used too much force. So she walked away with this fine. She is not crippled, was bruised up, maybe just a tiny bit. And this person was a big person. And I'm out of time now, and I appreciate y'all's attention.
Thank you, Mr. Wolf and Mr. LaQuire, for your arguments. We will take this matter under advisement.
Thank you.
Thank you.
This honorable court stands adjourned.
Thank you, Ms. Lindsay, and counsel, you are welcome to exit the meeting.